Thank you so much, Eve, for that very kind introduction. And thanks to Christina and all the team in the Hub for all their great organization. It's so exciting to get to participate in this festival, which I just think is such a wonderful idea to promote and highlight what goes on in arts and humanities research and to talk a little bit about the things that interest us most. And I'm particularly interested in speaking at this festival because, as you'll see over the next while, I think that law is one of the great forgotten humanities. We are honoured to be a member of the Faculty of Arts, Humanities and Social Sciences in this university. We are even more honoured to be an active member of the Long Room Hub here. But we are also, given the unusual nature of our discipline, a member of our Social Sciences Research Hub, TRIS, which is also wonderful. And I think we might be one of the oddest members of both of those groups because law is a strange discipline. It's not quite a humanity. It's not quite a social science. It's not particularly good at embracing well the methodology of either of those academic traditions. And while this is changing and more people are embracing social science and humanities methodologies, our people have largely kept to themselves in their research, doing our strange work off on our own. And frankly, maybe everyone was happier that way. But we have started to branch out and add ourselves into other parts of the university. And I think that's really important because I think law is the frame in which life plays out. And I think it shapes just as it's shaped by the human condition. And it's my case that the academic study of law should be a humanity, maybe much more than it usually is. And the study of law as a subject in university should be that way too. And I think the practice of law and law in all of life would be enriched by a humanities perspective on its subject and on its effect. And I spend a lot of my time on this now. I consider myself as much to be working on law and literature as on constitutional law, which is my primary field of research. And I was one of those odd people who always wanted to be a lawyer from pretty much as young as I can remember. And I know that's strange for a child, but my parents are here and will probably attest that it's true. Shortly after I gave up my dream of being a fire truck, not a fireman, a fire truck, because I was told it was something of a closed shop and you have to be born into it. Being disappointed about that, my sights immediately turned to law, and that was that. And I know that's odd, but it was always true. But all through life, I was a lover of literature, and reading had always been a huge part of my life. But I think training for law here, which I started 20 years ago this year, almost killed my love of reading. And that's some of the background to my talk today. I became something of a lapsed literature lover, an aspiring literature lover rather than an active one, much to my great sadness. And I found it harder when I was a law student to connect with books the way I had before. But over time, I kept on finding ways to try and bring it back. And now I'm something of an ardent preacher of law and literature as being deeply connected and intertwined. I think lots of law students, as I've learned in my 12 years teaching here, thought about or maybe even really wanted to study English literature instead. I think a number of them definitely would have done so, except for well-meaning parents who, rightly or wrongly, think there's a better buck in my racket rather than Eads and give them advice accordingly. Whether that's good advice or not, I won't comment. I don't meet as many literature students as I would like in the classroom, would like to find opportunities to meet more. But I suspect that quite a few of them were tempted over our way before they settled on going to the School of English. I met just on Saturday evening a recent graduate of the School of English on her way to the King's Inns. I know lots of lawyers in practice who did English literature as their undergraduate study. And at one point in my life, I thought this was maybe a strange overlap, that these were dual interests that didn't really come together very easily. But I don't think that now. I think instead that law and literature are maybe even to a surprising extent kind of the same enterprise. As two scholars I'm very fond of, Weisberg and Baricelli, put it, they are both formalized attempts to structure reality through language. And to dwell on that for just a second, both law and literature as objects of our attention are trying to grapple with reality. They're both trying to structure it and do it formally. They're both part of an ordering process as we try to set things in some sort of cognizable structure. We both use language as our tools of trade. We're both very interested in interpretation of text, albeit in different ways. And I think we're both interested in ambiguity. But we're interested in ambiguity perhaps for very different reasons. Lawyers want to kill it as much as humanly possible, whereas I think perhaps literary scholars enjoy reveling in it or even creating it at times when clarity might briefly break out. So those are different approaches, but they're the same object of fascination. So why do lawyers need to read literature, which is the title of my talk today? I'm basing this in part on material in my recent book and also on an article that actually was published today, as it happens, didn't plan that, in the Yale Journal of Law and Humanities, which you're more than welcome to read if you want even more of this that I'm going to provide over the next 20 minutes or so. And there's two reasons that I think it's really essential that lawyers engage with literature. The first is to stop being lawyers and to remember how to be human. And I'll come back to how insulting that sounds in a second. And then I think to understand the law better, to be better lawyers, to understand the law in a broader and deeper way than legal education tends to teach us. And in both of those, the recurring theme is how to bring the human back. Might sound like I'm saying that lawyers are less than human. I'm not exactly saying that, but I'm not saying it either. And I'll get on to that in just a moment. So, first of all, why do lawyers need to read literature in order to be human? The first reason, I think, relates to lawyers not being the most popular. And let's delve into exactly what that means and why that is. There aren't many professions, if you think about it, that have entire genres of jokes devoted to making fun of them. If you take that there are few in that category, there are even fewer where all the jokes are mean. All the jokes are about how awful or greedy or heartless we are. We're unfeeling, aloof, detached, disengaged from how real people feel and think. We exist on some weird plane of existence that seems to make sense to us, but that everyone else finds strange or possibly abhorrent. That seems to be kind of the general genre of these jokes. Just to give you one of my favorites, there's a joke about candidates being put forward for an organ transplant, various people who are organ donors. One is a young, healthy athlete, died in a tragic car accident, whose organs are pristine and is obviously such good health. The other is a hard drinking, hard smoking lawyer of 40 years experience. And both of these are presented to the doctor during the transplant. And he says, well, it's a heart transplant, and I'd rather take a heart that's never been used. So we'll go with the lawyer in this situation. And it's a good gag, but we laugh because on some level we kind of think it's true. And that's what I mean when I talk about lawyers not seeming or not being fully human. To take another example, this time from literature, Hilary Mantel, who I talk about a lot in the book and is maybe my favorite writer, she wrote a very interesting vignette with her character Thomas Cromwell from the Wolf Hall books, where Cromwell, who was Henry VIII's chief minister and maybe the most brilliant legal character in fiction, is talking to his son Gregory shortly after he has orchestrated Anne Boleyn and several of Henry's courtiers to be executed, beheaded, for alleged treason and adultery, which almost certainly was made up, almost certainly didn't happen. And Cromwell's son Gregory asks him, were they guilty? And Cromwell says yes. But he realizes that they're asking different questions. When Gregory asks him, are they guilty? Gregory means, did they do it? But when Cromwell answers yes, he's answering a slightly different question. Did the court find them guilty? He's happy to say yes to that, even if he knows that the answer to Gregory's question is something else. And he follows up with a beautifully expressed thought, which is the lawyer's world is entire unto itself, the human pared away. The idea that lawyers exist in this parallel world where we shave back human feeling, sympathy, sentiment to get the hard job of law done. And it's my case that this is true, and that learning the language of law and the mode of thought that law teaches you is something that is genuinely useful, quite brilliant in some ways. And it does lots of useful things for you. First of all, it unlocks a lucrative and grudgingly respected profession that you can join and earn a good living from. That's not nothing. My students' parents certainly think that that's worth hanging on to. But it also gives you some kind of secret knowledge about navigating life. because it gives you knowledge about things that were previously very opaque to us. The kind of labyrinthine logic and language of law, its pointless Latin phrases, its hidden meanings and perspectives suddenly become open to you. And lots of things that were confusing before now seem at least clear. The mysteries of the criminal trial, which are one of the most important institutions in our society, things that people don't understand, how highly probative evidence just gets thrown out and ignored. We understand that when we learn the law. The wilderness of mirrors that is the administrative state, why bureaucracies behave in this weird way around us. We understand that when we study law, and we can even trick it into doing the things we want. It's kind of like being the only person in the room who's read the rules of the board game you're playing, because the rules are really obscure and weird and written in a language that no one is bothered to learn. That's kind of what it's like coming to learn the law. And so it's really, really useful, but it's also really limiting. And it's something that entails a loss as well as a gain. It's not just learning, it's unlearning, and it's even renouncing. There's a cost, I think, to learning to speak and think like a lawyer. And I think that most students, not just of law, but of anything else, don't really think of education entailing a loss. I think we have a ratchet-like liberal vision of education, where the only thing education does is maybe eliminate ignorance, but that's all that's lost, and ignorance should always be lost in favor of knowledge. And I think we don't think enough about the idea that there might be merit, virtue, and even wisdom in not knowing certain things and in not thinking certain ways. Learning is a bias too. It changes the way you think, sometimes for better and sometimes for worse, depending on your perspective. And so to consider this briefly, I'd like to talk about a piece that Mark Twain wrote, and it was used to brilliant effect by maybe one of the first law and literature scholars of the modern age and one of the best, James Boyd White, an American scholar, who highlighted this Twain piece. It's from Life on the Mississippi, which was Twain's memoir about steering a steamboat before his literary career and before the Civil War. And it contains many vignettes from his this time in his life. But one of the most interesting is when he talks about learning to pilot the boat, when he didn't really understand and he came to become a competent steamboat pilot. When he started out, there were lots of things he couldn't work out, lots of things he couldn't figure. He couldn't tell the difference between a bluff in the river that he had to steer around or the ship would be wrecked, or a pattern of the wind blowing across the Mississippi. He couldn't tell them apart, and he asked a more senior pilot, how will I be able to tell which is which? And the pilot says, you won't know what you've learned, but at some point you're going to figure this out. It will just become apparent to you which is a bluff and which is the wind, and you'll know, even if you don't know what you know. And Twain said he was right. Twain learned to read the river like a book, like it was a secret language that spoke of all these navigational puzzles. And he could read the river and everything it was going to do. But even though that was useful, made him a career as a pilot, and he found it very good knowledge, he lost something as well. And to quote, he said, I'd lost something too, lost something that I could never restore while I lived. All the grace, the beauty, the poetry had gone out of the river. And he says how he used to marvel at the sunset and find it unspeakably beautiful. And then after he had learned to navigate the river, he would see a sunset and say nothing more than, we're going to have wind tomorrow. Any source of beauty, the moonlight on the water, that would once leave him in rapturous awe, now meant nothing to him, so that to the point that he wouldn't even notice when the moon was making these beautiful patterns. As he put it, all the romance and the beauty was gone. Now, where am I going with this? What's this got to do with lawyers? Well, I think we do the same in law when we learn to read like lawyers. I think we lose the ability to read properly, to read just as readers, to read as humans. We learn an amazing language and a skill with words, but we lose the poetry and the beauty of language and the ability to appreciate that in the proper way. And that's because law is governed by what journalist Malcolm called the unwritten law of closure. Law's most important goal is to settle things, to give an answer. Ideally, to have rules so clear that no disputes arise. But if a dispute arises, to give an answer that is clear and authoritative and accepted. The law has to tell us guilty or not guilty, liable or not liable, you pay or you don't. It's most concerned with answers. And having an answer, one that's accepted and authoritative, is actually more important in many ways than what the answer is. It matters more to have some answer than to have a good answer. An answer that's good or fair, that makes society better. Lawyers kind of think that's secondary. That's someone else's job to work out what a good society is and how we should live. We're just going to apply the rules and make sure there's closure. And that's why in law, we are always and everywhere narrowing. From everything we might say about a particular topic or dispute, from all the huge complexities of social life that present themselves in legal problems, we need to boil that down to two sides of a case, one versus the other. And then, as quickly and cheaply as possible, we need to take two down to one. This is not an enterprise that is interested in openness or aesthetic pleasure or interest or anything else. We're interested only in one thing, which is narrowness and closure. That's all we ever read for, to extract useful meaning and advance legal argument. If we read any text, we do it to get a legal argument to beat someone else with, to extract a legal bon mot. And we don't just do that with legal texts. Give us history, give us sociology, give us economics, give us Shakespeare. We can find legal stuff in there. We can find ways to twist that into arguments to persuade a judge. And frankly, that is all we will read it for. Legal reading is extractive, it's utilitarian, it's ransacking, in the words of one legal scholar. I like the term strip mining, as they do in the United States. Seamus Heaney had a great metaphor about translation. He said there are two different types, and he engaged in both in his career. You could have a translation that's a settlement, where you kind of move in with a text, you make yourself at home, really understand it, come to an accommodation with it, and learn to live in sort of a harmonious fashion, like he did with his Beowulf, for example. Or his other example was a raid. You go in, you snatch the text, and you run out with whatever you can use for your own purposes. You're not really interested in what the text is, only in extracting something from it, as he did maybe with Agamemnon when he wrote the poem Mycenae Lookout. And the problem is that lawyers are always raiding. We are never settling. We don't reach an accommodation with any text. We just use it for what we can, and then we throw it away. And that can be useful. Just like Mark Twain learning to pilot the steamboat, there's something really helpful in that mode of reading. It lets us do the work of law. It's quite an amazing trick. Give us anything, we will turn it into a legal argument to advance our client's case. But it's not necessarily a great way of living. And I think when we learn to be lawyers, when we learn to think and read like lawyers, we lose what Twain lost. We lose the ability to ever encounter beauty, ever read texts openly, ever read texts richly and with curiosity, not as a lawyer, but just as a reader. And I think that tends to infect the rest of our lives because law is a totalizing profession. If you tell someone you're a lawyer, they infer various things about your character and behavior from that. As discussed earlier, few of them are good. They assume you're a certain kind of person and you do a certain kind of thing and care about a certain kind of thing. And as a result, law doesn't really stop at the water's edge. It becomes something that tends to infect your personality, as it were. But also, law is as wide as the Mississippi was for Twain because it touches upon so many areas of social life. This is not a highly specialist skill that relates only to some narrow area of technical expertise. All aspects of social life are influenced by the law. So the risk is you bring your legal mind, your legal language to bear on every aspect of your thought about life. And that is terribly, terribly narrowing. I think legal education is teaching you not to read in a very real way. It's teaching you to ransack texts for legal use. And that's incredibly useful, but we have to overcome it. I think that many people do over the course of their legal careers and their legal education, but some don't and some struggle with it. And I really think that engaging with literature in just an open and curiosity-based way is the answer. When we force ourselves to read literature, we re-engage, I think, with the human, with the open, with the curious. That is, with beauty and romance. Not to get anything particular out of it, not even to be better people, just to read, just because it's fun, just because it inspires us, just because our curiosity is piqued. If we can do that, It forces even those who have had their minds warped by legal education to open up again just a little bit, to bring the human creeping back in. And that is how I think we bring the human back. Not only then is that important for lawyers because it's nice to be better people, I suppose, but it's really important, I think, for the law itself. Because the law isn't or shouldn't be an inhuman practice aloof from human feeling. The law sometimes requires us not to be emotional in our practice, to put aside the specific human suffering in a particular case because that's our job. But that doesn't mean you have to be hard to it. It doesn't mean that you have to ignore the human consequences of our profession and our action. We will be better lawyers as well as better people, I think, if we find ways to always remember the humanity that undergirds every aspect of legal work. And that's my first case for lawyers reading. We need to remember to be human, and literature really helps us do that. My second reason then is going to give lawyers something, because as I said, we want things to be useful. So now I'm going to say why it's actually useful for lawyers to engage with literature and actually helps you in a very real way think about law more deeply. So my second argument today is that if lawyers read literature, they will see the law more clearly. They will see what the law is in a deeper and broader way than if we confine ourselves to legal thinking alone. Because I think if you cast off the narrow lens of the law, you will see something that is much richer and much better than the mere legal perspective allowed. So I've just finished this book. It's very expensive. Please don't buy it, but encourage your library to do so if you're in an academic institution. Someday it might come down to a human price, I'm hoping next year. And basically, I'm trying to explore the law through literature. It's the culmination of many years of thinking about this. And what do I mean when I say literature? What do we learn about the law by reading literature? I'm not talking about literature in a very narrow sense. The title of the talk is From Henry James to Star Wars, and I really mean it. I think everything along the spectrum, from high literary novels to really quite questionable quality pop culture science fiction films, depending on what era of Star Wars you're watching, can hold really valuable lessons for understanding the law in a deep way. So I'm not just meaning high literature, I'm not just meaning things that might be worthy of academic attention in literature departments, though people have very broad and wonderful perspectives in literature departments here and elsewhere. I think various literary sources are really, really useful for this. I also think it's not just about books that are really about law, because law affects so many aspects of social life. So many different kinds of literature teach us lessons about what law really is and show us law in a new way. And so the example that I want to discuss is Henry James, because I promised I would do that. And this relates very directly to the book. So I think literature can be better than legal materials in illuminating what the law is, and in particular can serve as a kind of legal theory. Literature can be a theoretical text for law, and a better one than the theoretical text that we produce. That's my argument in the book. This is sometimes called literature as jurisprudence, jurisprudence being legal theory. Literature can serve as almost a theoretical window into the law. The reason for that, I think, is the same as what I was talking about earlier. Literature can be a deep insight into law's nature precisely because it's broader than legal material. Legal material is not only narrow, it's also justificatory. Lawyers feel it's part of our job to uphold the authority and validity of the legal system. We have to be cheerleaders for law as a thing. We can't really go around saying it's not up to much. We have to present the idea that the law is doing something deeply worthwhile. And I think we also really believe that. But as a result, all the materials we produce justify the law. Say it's broadly good, going in the right direction, knows what it's about. It doesn't explore law's blind spots, law's weaknesses. And what literature can do is take the legal context from this narrow intellectual surrounding and crack it open. Show us something about the law we can never see from the angle that we look at it. It can introduce a deep critique that is otherwise inaccessible to legal language. Neither the weeds of legal doctrine that we analyze when we look at case law, nor the justificatory legal theories we put out in our scholarship can do this. I think literature can. And that's what my book is trying to do. So the argument in the book is basically that law is fundamentally an anti-theoretical practice or a pragmatic practice. It uses the idea of philosophical pragmatism, which says that the world is too complex to ever be governed by principle or theory. And it says that that is true of law. Law is not a theoretical enterprise. Law is an enterprise of working out pragmatic compromises that help us live together in a society. And all the theory we dress it up in is really more of a justificatory rhetoric for what law is doing. And the way I wanted to argue that, in part, is with the novels of Henry James. And I use lots of different authors in the book: Seamus Heaney, Hilary Mantel, Harper Lee, Janet Malcolm, the nonfiction writer, lots of different people. But Henry James is, in a way, the heart of it. And this is why. The philosophy of pragmatism came from William James, a philosopher and psychologist of the early 20th century and late 19th century in America. And William James was quite a brilliant individual who wrote an incredible book arguing for this philosophy. His brother, Henry, was a novelist of some renown who wrote perhaps the greatest novels of human complexity that I've ever read. And William tried to argue for pragmatism in his philosophical works, and it kind of worked. And Henry, almost without knowing it, argued for pragmatism in his books. And when finally his brother William came out with this philosophy of pragmatism, Henry wrote to him and said, "I didn't realize that all my life I had philosophically pragmatized." He was a pragmatist in his bones without realizing it. And he's also a pragmatist in his books. Because if you want to understand pragmatism, you have to understand that the world is too complicated for theory or principle to comprehend. You'll never be able to work out abstract answers to the complexities of life. That fundamentally is what pragmatism stands for. William tries to say that in his philosophy, but you can't say that. You have to feel it. You have to know it to be true. Henry, in his novels, and his short stories indeed, which are just marvels of human complexity, shows this brilliantly because he shows that people are just too complicated to fully understand. The structures we are in guide us in ways we never fully comprehend. We do things that are unreadable sometimes even to ourselves. Nothing can fully explain the complexity of a person, Henry James tells us again and again in his masterful fiction. And my argument is by reading Henry James, you can realize, both directly and indirectly, the same is true for law. It's just too complicated to sum it up in a principle or a theory. You can't get easy answers in something like this. You have to embrace the complexity of life, and you have to see what that means for the object of your attention. I think that's a hugely important lesson for law. I also think it's a lesson that lawyers know in their bones. I think lawyers understand in practice that law is pragmatic. It is working out solutions, not a matter of high principle. But nothing in legal study has a language to express that. There is no theory that offers that insight to you. You have to find a way to feel it. And I think it is by reading literature, it is by engaging with works like the novels of Henry James, that we can see the law all around us for what it really is. We can see how it interacts with the complexity of life as lived. Not just a dry working out of disputes, but a deep attempt to grapple with complexity. I fundamentally believe that is what the law is. And I think the best way to see that and be convinced of it is to engage fully and openly with literature. Unfortunately, I don't have time to talk about Star Wars, but I also believe that Star Wars is important. And if you'd like to read about why, I have an article on the Trinity website and in a journal called Law and Literature discussing why the dreadful prequel trilogy is a masterclass in constitutional theory in teaching you that the rise of autocrats comes not from over-concentrating power in an individual. That does happen, but that's at the end. It's actually under-concentrating power and creating a weak and lethargic state that allows strong men to rise up and seize power. So if you'd like to read about why Star Wars is equally important as Henry James in this panoply of literature, I have many places you can do that. So, just very briefly to conclude, because my time is up, my point in all this is not necessarily that no one should be a lawyer and everyone should study literature. And I say that not just because I'm head of a law school and we need to keep our student numbers up for various financial reasons. It's because I think the law is a brilliant and an important thing to study. I really, really do. It's a wonderful thing to understand. But it's even better and so much richer if we can keep our connection to the humanistic study of things like literature that will engage us in an entirely new way. A very famous American judge called Oliver Wendell Holmes, who happened also to be a close friend of Henry James, once said that we can live as richly in the law as anywhere else. And I think he's right about that. But it's only true if we can find a way, after we've pared away the human, to find interesting ways to bring it back. Thank you so much, and I'd be delighted to take any questions.